So how can we tell what the meaning of subject to the jurisdiction thereof means? Well, in this case, it's pretty easy, since the person who proposed the language told us why. See, while the language of what would become the 14th Amendment was being debated in the Senate, one Senator, Jacob Merritt Howard of Michigan, proposed an amendment to the language. This amendment, which I have offered, is simply declaratory of what I regard as a law of the land already, that every person born within the limits of the United States and subject to their jurisdiction is by virtue of natural law and national law a citizen of the United States. This will not, of course, include persons born in the United States who are foreigners, aliens who belong to families of ambassadors or foreign ministers accredited to the government of the United States, but will include every other class of persons. See, Senator Howard specifically said he proposed this phrase, subject to the jurisdiction thereof, that it would not include foreigners, aliens, or those belonging to families of ambassadors or foreign ministers. Which means a claim that the Citizenship Clause contains no exception for children born to non-citizens or undocumented immigrants, probably known as illegal aliens, is obviously and objectively wrong. Now, also, since the Immigration and Nationality Act duplicates the language from the 14th Amendment, the complaint is just as wrong in that regard as well. Reading from Title 8, Section 1401 of the United States Code. The following shall be nationals and citizens of the United States at birth, a person born in the United States and subject to the jurisdiction thereof. So when the court claims that birthright citizenship is enshrined in the Constitution and federal statute, that's patently false.